Good evening. Today I intend to talk regarding the subject matter law and literature, its interaction with each other. Law and literature and legal literature are two distinct but related concepts in legal studies and humanities. Law and literature, this interdisciplinary field explores the relationship between law and literary works. It can be divided into two main approaches. Law in literature, it examines how legal themes, issues, and institutions are portrayed in literary works. Examples include, I quote, To Kill a Mockingbird by Harper Lee, Bleak House, written by Charles Dickens, and The Trial, Franz Kafka. Now, law as literature, it analyzes legal text such as statutes, judgments, and legal opinions using literary techniques like narrative analysis, rhetoric, and interpretation. This approach sees legal writing as a form of storytelling. Now, this field helps in understanding justice, morality, and the human impact of legal systems. Regarding the legal literature, it consists of primary sources, including statutes, case laws, constitutions, and treatises. Secondary sources are legal textbooks, commentaries, law review, articles, treatises, and legal encyclopedia. And we also call it as a practical literature. It consists of legal manuals, practitioner guides, and judicial opinions. Now, the legal literature is used by lawyers, judges, and scholars to interpret, apply, and develop legal principles. Now, if we like to go a little deeper into it, we find that let us try to go a little deep into the intersection of law and literature and legal literature as well. Now, the relationship between law and literature and legal literature is deeply intertwined, influencing how we understand justice, legal systems, and human rights. Below, herewith, I intend to make in depth, little bit, exploration of each key categories. First category, in my opinion, it will be judicial opinions as literature. Now, many legal judgments go beyond mere legal reasoning. They use narratives, rhetoric, and literary techniques to persuade, clarity, or even dramatize. Now, the key examples under this category I would like to quote Justice Oliver Wendell Holmes, Jr., US Supreme Court. In his opinion, in the famous case Buck versus Bell in the year 1927, upheld forced sterilization laws and contains the famous phrase, I quote, the three generations of imbeciles are enough. The rhetorical force of this statement highlights the power of legal language, though legally sound at that time. Its literary weight contributed to its later condemnation. Now, let us refer to Justice Benjamin Cardozo, US Supreme Court and New York Court of Appeals. Now, his ruling in Postgraph versus Long Island Railroad Company 1928 uses storytelling and metaphor to explain causation in negligence law. The famous quote in this case is The orbit of the danger must be traced to the eye of reasonable vigilance. The Cardozo's judgments are often studied not just as law but as literature, given their poetic structure and moral undertones. Another important judge, Lord Denning of UK Court of Peace, one of the most famous literary style judges. His opinions are accessible, vivid, and even dramatic. In a famous case in Miller versus Jackson in the year 1977, a case about cricket balls damaging property, he opened with, I quote, "In summertime, village cricket is the delight of everyone." Now, his storytelling approach made examples, legal principles easier to understand. And therefore, the impact of these kind of judgments, we can say that judicial writing is not just about applying the laws, it is about persuading, shaping, and narrating. Judges who use literary techniques often have a greater impact on legal history and public perception. Second category, now we call it as literary works, how they're influencing law. Now, many novels and plays have shaped real legal reforms, exposing injustice and prompting social change. Let us give some little key examples about it. The Charles Dickens' Bleak House, 1853, critic of the legal system. The first point is that this novel exposes the inefficiencies of the Chancery Court in England. Second, the case of Jamadesia versus Jamedia drags on for generations, criticizing the slow and costly nature of legal bureaucracy. Third, it helped fuel legal reforms in the UK, leading to the Judicature Acts in the year 1873 to 1875, which streamlined court procedures. Now, second important judge or work, Harriet Beecher Stowe's work, I quote, Uncle Tom's Cabin, 1852. It was related to anti-slavery impact. And this novel dramatically influenced US attitudes towards slavery. It is said that when Abraham Lincoln met Stowe, he remarked, I quote, "So you are the little woman who wrote the book that started this great war." While an exaggeration, this work helped lay the groundwork for the abolitionist movement and legal changes, including the 18th, including the 13th Amendment. Another work, Harper Lee's work To Kill a Mockingbird in the year 1960. It relates to legal ethics and race. Through Atticus Finch, the novel presents an idealized vision of legal ethics and moral courage. Now, this book is often cited in discussions about race, justice, legal responsibility, inspiring lawyers worldwide. Now, the impact of these works, we say that literature has shaped public perception of legal issues, justice, and legal responsibility, inspiring lawyers worldwide. And third category, now let us talk about the third category here, law in literature and its impact on legal thought. Now, many novels depict legal themes in ways that challenge legal assumptions and expose injustice. Let us give little examples about it. Franz Kafka's work, The Trial, 1925, critic of legal bureaucracy. Now, the protagonist, Joseph K., is arrested and prosecuted without ever knowing what crime he committed. A metaphor in this context for arbitrary law, bureaucracy, and loss of individual rights was conceived. And the novel has influenced legal critics on due process and government overreach. Another important novel, Shakespeare's The Merchant of Venice. The concept here is justice versus mercy. The courtroom scene explores strict legal enforcement versus ethical mercy. Skylark's insistence on the law, the pound of flesh versus Portia's plea for mercy, is a foundational legal debate on rigid law versus equitable justice. Another important work, Dostoevsky's Crime and Punishment. It is here the concept is legal versus moral guilt. The novel questions whether legal punishment can truly address moral wrongdoing and influences debates in criminal law about rehabilitation versus retribution. So, in this way, literature provides a human perception on law, often challenging legal norms and sparking new interpretation. The fourth category is known as legal literature using literary techniques. Some legal writing blurs the line between law and literature using storytelling and emotion. The key examples in this category would be Brian Stevenson's work Just Mercy in the year 2014. It is a non-fiction as a legal novel, a real-life legal memoir that reads like a novel, tells the story of wrongful convictions, humanizing legal struggles, and his influence discussions on criminal justice reform and death penalty laws. Another example can be given of Scott Tarrow's 1L. Now, 1L is the work name and it narrates to the legal education through storytelling, a semi-autobiographical book about the experience of law school. It balances real legal analysis with the narrative's depth of fiction. The impact of these techniques would be that legal literature with strong narratives and human-centered storytelling often reaches a wider audience and influences legal thought more effectively. Another category may also be called as fictional law creating real legal debates. Sometimes fictional legal dilemmas lead to real world discussions and policy changes. Now, for example, Arthur Miller's work, The Crucible, in the year 1953, it is related to political trials and legal paranoia, though about the Salem witch trials, it was an allegory for McCarthyism, and it used in debates about the process, mass hysteria, and political persecution. Another work, fictional, George Orwell's 1984, entitled 1984. It is here with privacy and government surveillance. Concepts like Big Brother and though crimes have influenced real legal debates on privacy, digital rights, and surveillance laws. Now, John Grisham's legal thrillers are also one of the fictional laws, we can call it. Now, while fiction, books like, I quote, The Firm and The Pelican Brief highlight real ethical and legal dilemmas in the legal profession. They influence public perception of lawyers, corruption, and justice. So we may say like this that the fictional cases often lead to real legal debates and shape legal discourse on emerging issues. So we may call it, in conclusion, the power of law and literature and legal literature. The basic salient features would be number one, the legal judgments tell stories. Judges use literary techniques to persuade and clarify. Literature influences legal change. Novels exposes injustices, shaping public opinion and reform. Fiction challenges legal thought. Novels like, I quote, The Trial force us to rethink justice. Legal writing can be literary. Books like Just Mercy make law accessible, and fictional law sparks real debates. Works like 1984 impact modern legal policy. In this way, the intersection of law and literature, it bridges the gap between legal reasoning and human experience, showing that law is not just about rules, it's about stories, ethics, and justice. Now, it will be very pertinent in this context to also discuss intersection of law and literature in the context of India. In India, law and literature intersect in unique ways, reflecting the country's diverse legal and literary traditions. Literature has played a major role in shaping legal consciousness, exposing injustices, and influencing legal reforms. At the same time, judicial opinions in India often exhibit literary depth and rhetorical power. Let us see the first point, judicial opinions as literature in India. Indian judges have often used literary techniques in landmark judgments to make legal principles more accessible and persuasive. Key examples, let me quote and start with the very prominent, famous Justice Viran Krishna Iyer, Honorable Supreme Court Judge, known for his poetic and philosophical judgments. In Maneka Gandhi versus Union of India 1978, he expounded the interpretation of Article 21, right to life and personal liberty, using powerful prose to argue for due process and human dignity. Another famous judge, Justice P.N. Bhagwati, known as the father of PIL in India, in Bandhua Mukti Morcha versus Union of India 1984 case, he used empathetic, almost literary language to describe the plight of bonded laborers, pushing for stronger enforcement of human rights laws. Another important judgment, famous judge, Justice D.Y. Chandrachud, recent landmark judgments. His opinion in cases like Mafte Sindhu Johar versus Union of India 2018, which decriminalized homosexuality under Section 377 IPC, include historical references, personal liberty rhetoric, and poetic language, reinforcing law as a narrative of justice. Now, let us see how the literary works, they are influencing Indian law. The Indian literature has been a powerful tool for social and legal change, shaping reforms in caste, gender rights, and freedom of expression. The key examples, Mulk Raj Anand's famous work, Untouchables, 1935. Now, its impact on caste laws. Now, this novel exposes the horrors of untouchability through the life of Bakha, a Dalit sweeper. It contributed to public debates leading to laws against untouchability including the Untouchability Offences Act 1955. Another important author and poet, writer, Arundhati Roy's work known as The God of Small Things in the year 1997. It relates to gender and caste in law, and it deals with gender decriminalization, caste violence, and legal injustice. And it highlights real life legal issues and biases influencing discussions on women's rights and caste laws. Another important work, Salman Rushdie's famous work, Midnight's Children in the year 1981. It relates to freedom of speech and censorship. Now, a critic of emergency era India, this novel was banned in some places and sparked large legal debates on freedom of expression, Article 19, Clause 1A. Now, Periyar's writings and Dravidian movement, early 20th century. Now, his works, including, I quote, Why Were Women Enslaved? It challenged Hindu orthodoxy, caste discrimination, and women's oppression. And it influenced the legal changes in Tamil Nadu, such as reservation policies and gender rights reforms. So we see now that literature brings social issues into legal consciousness, influencing legal activism and policy making. Third category in the context of India and law in Indian literature and its impact on legal thought. Now, several works of fiction. Now, I will be talking about the many references of fiction. Key examples are Munshi Premchand's Godan, 1936. It relates to land laws and peasant rights. It explores rural injustice, land ownership, and debt bondages later reflected in land reform laws in India. R.K. Narayan's work, The Guide, 1958, it relates to the criminal justice and morality. The protagonist Raju faces trial and imprisonment, raising questions about justice, fate, and personal redemption. Another important reference, Arvinda Adiga's work, The White Tiger, 2008, relates to corruption and legal hypocrisy. And it explores how law favors the rich, questioning judicial integrity and legal inequality in India. So we find that the fictional works, these novels shape legal discussions by portraying the lived experiences of law in Indian society. Now, we also see that the legal literature, it uses legal literary techniques in India. How the legal literature, it using literary techniques in India. Now, the following writings in India often blends technical law with literary and humanistic narratives, making law more accessible. Certain examples, a very important example is maybe given of Fali S. Nariman's work, Before Memory Fades. Now, it's a memoir by the eminent lawyer, blending legal analysis with storytelling, and it covers constitutional law, emergency excesses, and personal experiences. Nani Palkewala work, We the People. It uses rhetoric and historical storytelling to discuss constitutional democracy and legal challenges in India. Another important work of Justice Leila Seth's, Talking of Justice. Now, this work, it blends legal history with personal account of gender discrimination and judicial reforms. So we find that these works make complex legal issues engaging and influencing public understanding of the law. Now, let us see also some fictional law creating real legal debates in India. Many fictional legal controversies have triggered and real world debates and lawsuits in India. We can start with the censorship cases on books and films. Now, Satanic Verses, Salman Khurshidi, the work was banned in India for allegedly violating blasphemy laws, Article 295A IPC. The Da Vinci Code, it faced legal battles in India over religious sensitivity and free speech. And Padmavat, the movie 192018, it led to legal disputes over historical interpretation and artistic freedom. Let us refer to certain Bollywood films depicting legal struggles. Now, the film Pink in the year 2016, it critiqued the misuse of legal systems against women, influencing conversations on sexual consent laws. Article 15 movie in the year 2019 exposed caste-based discrimination linking to Article 15 of the Indian Constitution. Let us refer to very famous trial of famous artist M.F. Hussain in the year 2006. Renowned artist M.F. Hussain was legally attacked for his artistic depictions of Hindu gods, leading to debates on freedom of expression versus religious sentiments. So we find that fictional legal controversies often lead to real judicial decisions, influencing censorship laws, free speech cases, and public perception of justice. So we find, in conclusion, we can say that the role of law and literature, the major points in conclusion may be stated as follows. Judicial storytelling makes law accessible. Judges like Krishna Iyer and Bhagwati, they used literary depth in landmark judgments. Indian literature has influenced legal reforms. Novels like Untouchables and The God of Small Things highlighted social injustices shaping legal discourse. And frictional law often leads to real legal challenges. Films and books sparks debates as discussed above on censorship, caste, and gender rights. So, and another very important point in the conclusion, it may be stated that the legal writing in India blends storytelling with law. Works by Palkiwala, Nariman, and Leila Seth show how legal literature can be both analytical and engaging. So in this way, we find how the law and literature has been interrelated with each other at the word level, and we have also referred it in the context of India. So thank you very, very much. Thank you very, very much.